Welcome to Glorious IAS Academy. I hope you all are doing well. In this video, we'll be discuss the governor. This is the first video of the governor. In this video, 6 different topics would be discussed on governor. First one, appointment of the governor. Second one, qualifications of the governor. Third one, oath or affirmation of the governor. Fourth one, conditions of the office of governor. Fifth one, privileges and immunities provided under the different constitutional provisions. And sixth one, term of the governor. Next one, executive. Before going to discuss about the governor, let me have a quick revision of what is state government. In last video, we have discussed elaborately what do you mean by the state government. State government consisting of 3 components, 3 branches. First one executive, second one legislature, third one judiciary. So these are the 3 branches of state government. 3 branches of state government. Executive will implement the laws, will enforce the laws. Legislature will make the laws, and judiciary, high court and lower supreme court, high court and its subordinates commonly known as state judiciary. So high court is the highest state judicial office in any state. So here we start the discussion about the executive. This class is the starting class of executive. In this class we are going to start the discussion about the governor. So what do you mean by the executive? Executive will have 3 components. Number 1, governor. Number 2, CM. Number 3, council of ministers. So there will be a few lessons on the governor. One lesson will be on the chief minister and one lesson will be on the council of ministers. So executive consisting of governor, chief minister and council of ministers. And legislature nothing but state legislative assembly. Judiciary nothing but high court and lower courts. So in this class, this is the first class of the state executive, and after that we will move to the state legislature. After that we will move to the state judiciary, that is high court and lower courts. So let's get started. Article 53 to 167. Article 153 to 167 of Part 6. Part 6 of the Indian Constitution deals with the state government. State government, of which 153 to 167 deals with the state executive. 153 to 156, those are inserted in the part 6, which deals with the state executive. Here the governor will have dual role. Governor will have 2 important roles. Number 1, he is the chief executive head of the state. Here governor is nominal head. Nominal means he is the chief executive head. All decisions, rules and regulations will be framed. All decisions would be taken by the CM and council of ministers in the name of the governor. Here CM and council of ministers are considered as a real executive. Governor is a nominal executive under the parliamentary form of government that our constitution adopted, both at the level, state level and the central level. And another role of the governor is appointed by will be appointed by the President of India. So he will act as agent of the central government. He will agent. What do you mean by the agent of the central government? The main duty of the governor to ensure the constitution, provisions, protecting the constitution at the central state governmental level. So under Article 355, there is an article called Article 355. Under Article 355, it is the primary duty of the central government to ensure every state government carried according to the constitutional provisions. So central government will discharge that duty through the office of governor. Central government will appoint the office governor in every state. What is the main duty of the governor? Agent of the central government. He will act as agent of the central government. He will ensure the constitution should be carried in the state government. If any case any state government will not implement the constitutional principles, will not follow the directions given by the central government, under Article 356, under Article 356, governor can recommend the president to appoint or impose the president rule or the state emergency in that particular state. So that is called agent. That's why governor will act as agent of the central government to ensure the constitution, to protect the constitution at the state level. So that is, here one note will be there. 7th Constitution Amendment Act 1956 provides for a common governor for 2 or more states. So according to the 7th Constitutional Amendment Act, President can appoint a one person or a single person, a single governor for 2 or more states. And for example, ESL Narasimhan very recently, he appointed for as a governor for both Telangana and Andhra Pradesh states till 2019. Till 2019, he acted as governor for both states. So common governor provided by the 7th Constitutional Amendment Act. So first topic in this video, appointment of the governor. Who will appoint the governor? President of India will appoint the governor. Here, governor neither elected directly nor indirectly elected by the electoral college. Here you will see neither elected directly like MLAs, MPs, nor indirectly elected through the electoral college. But here we need to remember one point. President and vice president at the central level, they would indirectly elected by the members of the parliament and the legislative assembly members. President would be elected by the proportional representation system through the single transferable vote by the elected members of the parliament and state legislative assembly members. Vice president would be elected through the members of the parliament. Both officers would be elected through the proportional representation system, indirect elections. But here, governor will not be elected directly or indirectly. Simply he will appointed by the President of India on the recommendations of the PM and Council of Ministers. So here, President neither elected directly nor indirectly elected. He is just a central nominee. He will nominated by the central government and appointed by the President under warrant under his seal. So he will not elected, he will just appointed by the President of India. He will act as nominee of the central government and agent of the central government. Here in this case, there is one Supreme Court case is there, Hargovind Pant case in 1979. In this 1979 case, Supreme Court given a landmark judgment regarding the appointment of the governor. According to this judgment, central government should not use office of the governor as an employment opportunity for the political leaders. That means whoever the political leaders would not appointed as a direct elections, central government should not use this office to employ those political leaders. So here Supreme Court mentioned that it is not considered as an employment opportunity. It is independent constitutional office and not under the control of the subordinate to the central government. Even though governor would be appointed by the central government, it is not considered as the subordinate to the central government. It is an independent constitutional office. Governor will have the independence from the central government. That is the Supreme Court. That is the judgment given by the Supreme Court in the matter of appointment of the governor. Next one, why Constitution adopted the appointment system? Constitution does not provide direct elections or the indirect elections. If you take the case of USA, in USA governor would be appointed directly by the people, directly by an electoral college like president. But in India, just he will be appointed. If you take the case of Canadian model, governor would be appointed by the governor general. So in the same way, governor general in Canada is equal to the president in India. So we are adopting here Canadian model rather than the American model. So why Constitution does not provide elections system for the governor? These are the following reasons. That's why the Constitution does not provide. Number one, direct election is incompatible with the parliamentary system. We have provided the parliamentary system. In this parliamentary system, governor will act as just a nominal power. His real power vested in the CM and Council of Ministers. So it is not compatible. Number two, it creates a conflict between the CM and governor. If you provide elections for the governor, CM also would be elected through the people and governor also would be elected through the people. So there would be a conflict between governor office and CM office. So there will be a lot of conflicts going, there will be a lot of conflict if you provide the direct elections or indirect elections for the governor. So because of avoiding this conflict, Constitution of India does not provide election system for the governor. Next one, governor is just a nominal head, not the real head, and not in the national interest. If you provide the election system for the governor, every governor would be elected through a electoral college. It is a very hectic task for the Election Commission of India. It incurs a lot of financial cost, lot of resources would be used. So it is unnecessary to provide elections for the governor. That is, it is not in the national interest to involve large number of the voters in such elections. So that is one reason behind the appointment system of the governor. Next one, elected governor would naturally belong to a party. If you provide the election system for the governor, a party member would be contest for the governor. So if a governor elected from one political party, CM will be another political party, there will be a tug of war again, there will be a conflict arises between two political parties. There will be a lot of confusion. Next one, it creates separatist tendencies and affect the political stability and unity of the country. So that is one more reason, and enables, if you does not provide, if this appointment system, if you does not provide the election system, if you provide appointment system, this appointment system provides, it enables or provides central government to maintain control over the states. Why? It is the primary duty of the central government to protect the unity and sovereignty and what is the security of the country and ensuring the every state government to carry according to the constitutional provisions. So in order to fulfill those duties, it is mandatory for the central government, it is mandatory for country to appoint governors by the central government. So governor would act as an agent of the central government in order to protect the constitution at the state government level. So that's why the constitution does not provide the election system for the governor. It provides only appointment system. Look at here, American model. In America, governor is directly elected. In Canada, it is appointed by the governor general. Governor general nothing but president in India. So we are adopting our constitution accepted the Canadian model rather than American model. Number two, second topic in this video, qualifications. There are Indian constitution provides for only two qualifications to be appointed as a governor. Number one, he should be a citizen of India. Number two, he should cross the 35 years of age. So if he fulfill these two qualification, that person would be eligible to appoint a governor. But central government appointed a commission called Sarkaria Commission. Sarkaria Commission given certain recommendations on the qualifications of governor. First qualification, he or she should be eminent person, number one. Number two, he should be that person, the governor should be outside of the state. If a governor of the Telangana should not belong to Telangana politics, he should belongs to outside the Telangana. He may belongs to Tamil Nadu, he may belongs to Karnataka, he may belongs to Kerala. So outside person, out of state person should be appointed as governor according to the Sarkaria Commission. Third one, he should be detached figure from the local politics. Very recently, he should not connected to the local politics. Fourth one, he should not take to great in politics. He should not take part to great in politics. Means in recent times, he should not be participated in the political affairs or political matters. So he should be away from the politics. Second qualification given by second recommendation given by the Sarkaria Commission regarding the qualification, a politician should from ruling party at the center should not be appointed as the governor of state. Suppose the BJP government is there, a BJP person should not be appointed in any particular state government. That person should not belong to ruling party. Those who are ruling at the central government or the state government, the person belongs to those ruling parties should not appointed as the governor. That is one recommendation given by the Sarkaria Commission. Next one, while appointing the governor, while appointing the governor, central government should consult the Vice President of India and Speaker of Lok Sabha. So that is one recommendation given by the Sarkaria Commission. Third one, oath and affirmation. Oath and affirmation of the governor. Oath and affirmation is administered by the Chief Justice of the concerned High Court, concerned State High Court. For example, the governor of the state, the governor of the Telangana would be administered by the Chief Justice of the Telangana High Court. So like that, every concerned State High Court Chief Justice would administer the oath of governor. And the senior most judge, if he, in case of the Chief Justice is absent, senior most judge of that particular High Court would be administer the oath and affirmation. What do you mean by the oath and affirmation? First one, to faithfully execute the office. Second one, to preserve. This is the main duty of the governor. To preserve, protect and defend the constitutional provisions and law. Third one, to devote himself to the service and well-being of the people. So these are the three main oath or affirmations of the governor. Fourth one, conditions of the office. What are the facilities would be provided to the governor office, and what and all governor should not do and should do. And first one, he should not be a member of the either house of the parliament, either house of the state legislative assembly. He should not belongs to either member of the state legislative assembly, or he should not belongs to member of legislative council. Second one, he should not hold any office of profit or any company, any organization which give monetary benefits to that person. It is called office of profit. What do you mean by the office of profit? It is an office which will give monetary benefits. So the person who is appointing for the governor, he should not hold office of profit. Third one, he can use his official residence, that is Raj Bhavan, without payment of rent. Second, third, fourth one, emoluments, allowances and privileges directly determined by the parliament. Here the governor emoluments and allowances privileges not decided by the state legislature, they are decided by the parliament. You should remember this point. Even though governor is working in the state government, governor is working in the state level, state legislative assembly will not decide. Parliament only decide the emoluments, privileges and allowances of the governor. Second, next one, emoluments and allowances cannot be diminished. They cannot be reduced while he is in office. During the term of his office, the allowances, salaries, whatever the benefits, those benefits should not be reduced. Either can be increased but should not be reduced. So that is one of the constitutional provisions regarding the conditions of office. So here one important note here. In 2018, the parliament increased the salary of the governor from 3.1 lakh to 3.5 lakh. Means right now the salary of the governor is 3.5 lakh per month. So that is the salary of the governor is 3.5 lakh. Next one, privileges and immunities of the governor. What are the different privileges and immunities provided by the Indian Constitution? Number one, personal immunity from legal liability of the official acts. So whatever the official acts did by the or will be done by the governor, those will get the legal immunity from all those official acts. So it is called legal immunity. Legal immunity. And two types of immunities are the legal immunity and criminal immunity. So during the next one, during the term of the office, he should be immune from any criminal proceedings. No criminal proceedings should be initiated against the governor while he is in office. So once he resigned from the office, once he removed from the office, criminal proceeding can be initiated. But as long as he is in the office, criminal proceedings will not be initiated against the governor. So this is called criminal immunity. Criminal immunity. So both immunities, legal immunities and criminal immunities. Third one, he cannot arrested or imprisoned while he is in office. Fourth one, but here civil immunity is not there. Civil immunity is not provided. Only criminal immunity and legal immunity is provided. Civil immunity is not provided. With 2-month notice, civil proceedings can be initiated during the office of governor. So governor will provide two type of immunities. Number one, legal immunity for his official acts. Number two, criminal immunity. But Constitution does not provide the civil immunities. Civil proceedings can be initiated against the governor while he is in office with 2 months advance notice to the governor. So these are the privileges and immunities of the governor. So sixth and final topic of this video is term of governor office. How many years the governor will stay in his office? So naturally or normally the term is 5 years, but he can be removed by the President of India at any point of time. So there is no security of tenure for the governor. So normally he will stay in his office 5 years, and he will, these 5 years is subject to the during the pleasure of President. What do you mean by the pleasure of President? Pleasure of President means President can remove him at any point of time. So there is no guarantee for the term of the 5 years. So here a Supreme Court judgment in 1981. In this judgment, Supreme Court given some of the judgments regarding the term of the office. So in Surya Narayan case 1981, Supreme Court told that pleasure of the President, this pleasure of the President is not justiciable. Not justiciable, nothing but President can remove the governor at any point of time. Second one, what Supreme Court told that there is no security of the tenure for the governor and no fixed term of the office. He can be removed by the President at any time. So Supreme Court judgment in Surya Narayan case told that governor can be removed by the President of India at any point of time. There is no security of tenure. There is no fixed term available. So as long as President want, he will stay in the office. If President wanted to remove, he can remove. And does not lay down any grounds for the removal. Constitution also does not lay down any grounds. So you no need to, central government no need to mention any grounds. They will, without any reason, they can be removed. They can be removed the office of governor. But for the grounds of the President, their incapacity and the misbehavior is the two main reasons for the removal of the President, removal of the Vice President, Speaker, Deputy Speaker, and High Court judges and Supreme Court judges. But here, the grounds for the removal of the governor does not mention, does not provided under the Constitution. Here, there are two examples are there. By this reason, the grounds does not mention in the under Constitution, it can be removed any point of time. By using these facilities that is provided by the Constitution, the government in VP Singh government in 1989, he asked the VP Singh government asked all governors to resign as they appointed by the Congress government. So it is same repeated in the 1991. In 1991, when Congress government came into power under the leadership of the P.V. Narasimha Rao, Congress government asked the all governors, those who are appointed by the earlier government. So like that, the office of the governor has become very controversial over a period of time, and they have been removing without any reason on will and wishes of the central government. So we'll be discussing those controversial topics in next few classes. So in this class we have discussed only 6 topics regarding the governor, and other than these 6 topics and more, next few topics will be discussed in the next video. Next one, the transfer. The transfer of next one, the transfer of governor. President may transfer governor to another state, one state to another state for remaining or rest of the term. Next one, reappointment. A person can be appointed n number of times as a governor after term is over. Maybe in same state or any other state, and beyond of he can be hold the office beyond of the term until a new person or successor assume the charges. Next one, the contingency situation. What do you mean by the contingency situation? Contingency situation that President in particular situations, in certain situations, President can make such a provision if she thinks it's fit for the discharge of the functions of the governor not provided under the Constitution. So any provision that does not mention under the Constitution, that provision can be made by directly by the President of India for the discharge of the governor. So indirectly, in other words, president can make any rules and regulations for the discharge of the governor in any state, even though they are not mentioned under the constitution. So that is, for example, during the death of the sitting governor, so during the death of the sitting governor, Chief Justice of concerned High Court may be appointed as temporarily. If there is a suddenly death of governor has happened, Chief Justice of that particular High Court would be appointed as temporary governor by the president. So these all about the 6 topics of the governor. In this we have discussed 6 topics of the governor. In next video we will discuss some other topics of the office of governor. Thank you very much.